thank everyone for being here today. Senator Wyden and Senator Markey and I requested this report that was issued today by GAO over 2 years ago. All three of us have spent years writing letters, having briefings, and holding hearings on this topic, and it's become very clear to us that despite all of our efforts, things were not getting better for whistleblowers at the Department of Energy. We're pleased with the extensive work that GAO has done. A representative from GAO is here today and will be able to answer any questions that you have at the close of our remarks. They reviewed 87 whistleblower cases that represented 10 of the largest Department of Energy sites by budget, interviewed numerous department and contractor officials. Most importantly, GAO heard from employees who are working in an environment that's not open, not safety conscious, and hostile to whistleblowers. My colleagues will introduce our two guests, two of the brave whistleblowers who have traveled a very difficult and dangerous path. But I want to just make a couple of points about hearings and legislative efforts on this topic. As I have said a number of times since I came to the Senate as a former auditor, whistleblowers are important to oversight of our government. They are eyes and ears many times where there are no other eyes and ears to open up wrongdoing to public scrutiny. I've pushed several pieces of legislation since arriving at the Senate to codify protections for whistleblowers into law, for federal employees, for workers in the intelligence community, and for contractors and grantees. I know we have heard the Secretary of Energy and his predecessors saying that things will get better, but based on the findings in this report that was issued today, it is clear the message has not been heard by the Department of Energy officials that are in charge of these various sites. I think it's really important to pause for a minute and realize that the Department of Energy, when you think of the Department of Energy, I think many people think of government employees. It is not government employees. It is, by and large, a contractor workforce. Just to give you an estimate of the numbers that we had when we did a hearing specifically on whistleblowers at the Department of Energy, 15,671 federal employees and 92,419 contractor employees. So there are 6 contractor employees for every 1 federal employee. That is why whistleblower protection for contractor employees is so vital. And keep in mind, these sites we're talking about are sites that we must have the highest safety standards. We're talking about sites that are dealing with nuclear energy. We're talking about sites that must be safe on a number of different levels in terms of our national security and worker safety. Several years ago, I was able to put in the Defense Authorization Bill a protection for contractor and grantee employee whistleblowers. It was went over to the House as a permanent provision of the law. It came out of the conference as a pilot program. That pilot program has been in effect, and during this investigation, GAO found that in some of the locations, in fact, the pilot program had been implemented, which provides an additional layer of protections and provides a much more a path that's not as difficult to come forward with whistleblower allegations. But they also found that 2 of the largest sites, including over 8,000 employees, Hanford and Savannah River, had not even bothered to implement the pilot program. So we have now passed through the Senate a statute that makes these protections permanent. And I am very pleased. We didn't know it when we planned this press conference. It's my understanding that today Representatives Shavitz and Cummins are introducing the House version of that bill that has in fact passed the Senate. I thank them both for that. I look forward to work closely with them to see if we can't get this through the process and across the finish line before the end of this calendar year, so that permanently going forward, the brave whistleblowers that are willing to come forward don't have to worry that there's 2 codes of conduct in terms of their protection, one for federal employees and one for contractor employees. And with that, I will turn over the microphone to, these are his digs, so to speak, as the ranking member on the Finance Committee, my colleague, Senator Wyden.
Thank you, Senator McCaskill, and it's good to be with you and Senator Markey. And as Senator McCaskill said, the 3 of us have been doing this a while, and I think it'd be fair to say we thought that we had seen it all. Today, however, it seems that there's a whole new precedent. We're talking about a contractor who was retaliated against for actually helping government auditors investigate retaliation against whistleblowers. Sandra Black will get a formal introduction from my colleague, was fired for cooperating with government accountability officers during an investigation for the report we're talking about. Now, when pressed, the auditors couldn't identify a single instance where someone providing information to them had ever been dealt with this way. We like firsts in America. We do not like this kind of first in expanding the consequences for people who blow the whistle in America. It's clear that Department of Energy contractors are going to go to amazing lengths to send a signal to their employees that when you blow the whistle, it is going to be the end of your career. One contractor employee summed it up this way. They said if they fired Sandra Black, who was in charge of dealing with whistleblower complaints, what do you think they're going to do to me? And if a Department of Energy contractor can obstruct a GAO investigation into whistleblower retaliation, what other GAO investigations at Department of Energy are going to be next? So you're obviously going to wonder, what did the Department of Energy do about this? The answer is nothing. Now, I'll wrap up by way of saying this is especially timely for us in the Pacific Northwest. Just this week at the Hanford Nuclear Reservation across the Columbia River from my home state, workers are walking off the job. They are concerned about exposure to toxic vapors from radioactive waste storage tanks. I met with several of them in May with the Washington Attorney General, and they said they feared coming forward to complain because they would be retaliated against. Mr. Tamosaitis is here. Where is Mr. Tamosaitis? Very good. And Donna Bushy complained about problems at a multi-billion-dollar waste treatment project in Hanford. In Donna's case, it's covered in the GAO report, her employers successfully obstructed an investigation into her termination, and this was an investigation requested by the Secretary. Now, the report documents a staggering array of other anti-whistleblower practices that the department has condoned. These include allowing DOE contractors to grade themselves on how well they treat whistleblowers. On this rig test, folks, there is no failing grade. The GAO report documents extensive mistreatment of whistleblowers by the department's contractors and stunning inaction by the department. In my view, the department is guilty of willful negligence at best, and at worst, actively aiding in the violation of whistleblower rights. So if the Department of Energy isn't going to get in the corner of the whistleblowers, it is up to us to change the Department of Energy. Senator Markey is going to go into a number of these kinds of issues, but obviously we have to beef up the penalties on contractors who retaliate, restrict the ability of contractors to bill the department in these kinds of cases, and give whistleblowers easier redress for the violations of their legitimate rights. Senator Markey.
Thank you, Senator Wyden. And Senator Wyden, along with Senator McCaskill, have given real leadership here in terms of calling for this report and having the public now have an opportunity to understand what the ramifications of it are. Would also like to thank Sandra Black and Dr. Walt Tamosaitis for joining us today. Your courage and commitment to the truth in the face of systemic resistance is an inspiration to everyone. This new Government Accountability Office report makes clear that the Department of Energy has utterly and completely failed to protect whistleblowers from retaliation. The currency of whistleblowers is the truth. But at the Department of Energy, whistleblowers are paid with harassment and retaliation. Whistleblowers are our modern-day Paul Reveres, shedding light on unsafe, wasteful, and possibly illegal activities. They should be applauded and rewarded, not threatened and fired. And the contractors who retaliate against whistleblowers should be held accountable. But instead of helping protect whistleblowers who come forward with serious safety issues, the department has helped protect contractors from whistleblowers' lawsuits. That's why even as far back as 2003, I requested information from GAO on this type of reimbursement of contractor litigation costs. And as I wrote again to Secretary Moniz in April this year, DOE has consistently provided contractors with indiscriminate reimbursement for their legal fees, a fact reaffirmed in the GAO's report. Contractors who engage in retaliation and harassment absolutely should not be reimbursed with taxpayers' funds for their legal fees. Not only does this practice waste millions in taxpayers' dollars, but it also allows contractors to endlessly appeal whistleblowers' lawsuits. Because whistleblowers lack the resources of the federal government to back their claims, contractors frequently win by default, even when they admit to wrongdoing in settlement agreements. And during the years of pointless and wasteful legal fighting paid for by taxpayers, the whistleblowers, who have sometimes lost their salaries, their security clearances, and their reputations, are left without jobs and without the ability to find one another. Why would we deliberately use taxpayer money to endanger public safety and discourage whistleblowers from coming forward to report security or safety violations or fraudulent activity? This makes no sense, and it may violate the provisions of the 2005 Energy Policy Act, which I authored to limit federal reimbursement for legal fees incurred in the defense of whistleblower cases. But turning Uncle Sam into contractors' legal piggy bank is only one of the failings that DOE outlined in this report. It also reveals a dangerous culture of disregard for the law among Department of Energy contractors. In November of 2011, I wrote to then Energy Secretary Stephen Chu to criticize the department's treatment of Dr. Tamosaitis, a former senior engineer at the Hanford nuclear waste site with more than 4 decades of experience. After raising serious and detailed concerns about the risk of catastrophic nuclear accidents at Hanford, Walt was demoted by his employers and put in a basement office with cardboard boxes for furniture. Walt's concerns about safety were ultimately substantiated by senior officials at DOE and other federal agencies, yet he was still terminated by the contractor. Subsequently, that contractor was forced to settle with Walt for $4.1 million in damages, but only after years and years of costly lawsuits and without any help from the Department of Energy, which could have used its influence to resolve the cases more quickly. Unfortunately, Walt's treatment is only the tip of the iceberg. Despite the department's promise in 2013 to promote a safety-conscious culture free from fears of reprisals, Energy Department contractors have continued to retaliate with impunity against employees who raise safety issues. Ms. Sandra Black was actually the person whose job it was to help whistleblowers come forward anonymously with safety concerns at the Savannah River nuclear site. But between 2008 and 2015, Sandra was subject to repeated harassment and intimidation by her superiors who obstructed her investigations, pressured her to illegally disclose the identity of whistleblowers, and attempted to remove her from her position when she refused to compromise her integrity. And after Sandra talked to GAO investigators working at our request on the report released today about her employer's actions, she was fired. This is the definition of adding insult to injury. It shouldn't be surprising, then, that GAO investigators were told that contractors had consistently created a chilled work environment. One employee told investigators, quote, "They fired Sandra Black. What do you think they will do to me?" The Energy Department must fundamentally reform the way it treats whistleblowers. Anything less will represent a betrayal of the heroism of Sandra Black and Walt Tamosaitis, and a fundamental failure to protect public safety. I think what we're doing today is we're saying that we're willing to stand with Sandra Black and with all of those people who are standing up for the truth. And no one can tell Sandra Black's story better than Sandra Black. She did everything right. She started in the typing pool at the Savannah River site, worked and went to school as a single mother, became a professional safety engineer, worked in the laboratory as a field safety technician, and finally became an employee whose job was to oversee a program. She had a 37-year record. She had the highest ratings, continuous promotions, bonuses that she received. No one had a better record than Sandra Black. And Sandra Black paid a horrific price for being courageous. So I would ask you, Sandra, if you come up here and please tell your story.
Good afternoon, everyone. First, I'd like to thank the senators for holding this press conference, as well as their staffs. Thank you all so much for giving me this opportunity. I also like to thank my friends and family for their encouragement and support during this very rough time in my life. Thank you, Billy Gard, for helping me seek justice. And I especially thank my son, Thomas, who is here today and has loved and supported me while I have grieved this horrid situation the last year and a half. I will now read my statement because I'm very nervous and my situation is complicated. So for the sake of time, this will allow me to tell my story the best way I can in this particular setting. As I said, my name is Sandra Hightower Black, and on January 7th, 2015, I was terminated from my position as the Employee Concerns Program Manager for Savannah River Nuclear Solutions at the Savannah River site in South Carolina, a Department of Energy and Defense nuclear operation. I was not allowed to return to my office, and I was stripped of my security credentials. I was offered 6 months' salary if I would sign a release that I would not bring any lawsuits or disclose any of my concerns. I did not accept that offer. My termination was the first time and only time in my 37-year career that I ever received any form of criticism or complaint. My record at the Savannah River site was spotless. From the time I started at the site in 1980 as an administrative assistant, through my years working as a laboratory technician, a field safety engineer, as a safety manager in the industrial safety department. In 1994, I became an employee concern program investigator, and I worked in the ECP program until I became the program manager in 2009. I was consistently given promotions, raises, advancements, and bonuses up until 2 months before I was terminated. During the month of October in 2014, I was interviewed by the General Accounting Office about the difficulties and challenges that I was facing in my job as an ECP program manager. I honestly disclosed to the GAO investigators significant interference I was facing in trying to run an ECP program with integrity. My disclosures included describing numerous incidents in which Mike Wamstead, an SRNS corporate lawyer, interfered with an ECP investigation, directed one of my staff members, an ECP investigator, to change the findings of a substantiated retaliation case to not substantiated, and cases in which SRNS executive management refused to take necessary corrective actions. I disclosed a recent incident in which an SRNS executive demanded that I disclose the name of a concerned employee to that employee's manager, saying, "Did you tell her the name of the rat in her organization?" Because I believe in the chain of command, I also disclosed my GAO conversations to Carol Johnson, the SRNS president, and repeated to her the details of the struggles I was facing in trying to investigate employee concerns and complaints of retaliation, as well as the lack of independence being afforded the ECP department. At first, I thought the SRNS president was listening to me, but I've since found out that within days of my disclosures to the president of my GAO conversations and my own complaints of retaliation against me for trying to do my job with integrity, the president made the decision to terminate me. The only explanation I was given as to why I was being terminated was because the company president had lost confidence in my ability to manage the ECP program. There was no legitimate basis for this complaint. The SRNS Employee Concerns Program had passed every DOE audit with glowing remarks. The only comment the president ever told me was that the other executives thought that I was an employee advocate. As I explained to her, I would not lie or cover up substantiated concerns or engage in unethical or illegal activities when I was directed to do so. The week after I was terminated, the ECP program was placed under the direct supervision of the very executive vice president, who referred to concerned employees as rats and demanded that I disclose these employees' identities. It is impossible to explain how devastated I am. I did nothing wrong. At 59 years old, I don't have another 37 years to build a new career somewhere else. I was proud of my job and did my best to manage an employee concerns program that would provide employees at SRNS a safe place to report concerns, to protect those that did, to resolve concerns as quickly as possible, and to ensure that credible and competent investigations into nuclear safety issues and complaints of retaliation were conducted when necessary. In fact, my job was to ensure that any and all concerns that impacted the public or worker health and safety, as well as protecting the environment, were promptly investigated and appropriate corrective actions taken. I followed the DOE order and guidelines to the letter on the management of the DOE program. And I followed the requirements as specified according to the DOE Savannah River Nuclear Solutions prime contract agreement with the government. When I was terminated, I first went to the DOE for assistance through the Section 708 process, but no one from DOE did anything to address my retaliatory termination. My very public termination has had a chilling effect across the SRNS workforce, and employees are now afraid to report safety concerns. And I'd like to refer each of you to the poster of some of those comments of what our employees have said in their fear for raising safety and health issues at this nuclear site, the Savannah River site. Additional comments can be found also in the GAO report as they captured them all on page 47. The very purpose of the program, to ensure that safety issues are addressed before catastrophic accidents happen, has been compromised. I had to retain a lawyer and have filed whistleblower complaints with the Department of Labor and the DOE Inspector General's office. I came to the senators for assistance, and they have tried to get answers about the truth of what actually has happened to me. This is not the way it was supposed to end for me, someone who gave so much to the Department of Energy mission and to the employees who served it. I want to thank Senators McCaskill, Senator Markey, and Senator Wyden for their oversight and using their positions to try and help me and to help other Department of Energy whistleblowers. When I was the ECP manager, I believed it when I told employees that retaliation would not be tolerated at the DOE. Now I know that wasn't true. All the words that DOE proclaims about wanting to have a strong safety culture, a safety-conscious work environment, and that it has zero tolerance for retaliation are pretense. The DOE has taken no effective action to prohibit or prevent retaliation or address the chilled work environment that permeates the Savannah River Site complex and does nothing when it occurs. Instead, the DOE enables the contractors to fight the legal battles against the whistleblowers by paying their litigation costs, charging this to the taxpayer, and creating the chilling effect that discourages honest employees from reporting concerns in the first place. The DOE doesn't want to know what is really going on with their contractors. Something has to change. I'm here today to be living testimony to ensure that this situation is addressed. And I'd like to leave this on page 47 of the GAO report, one of the quotes that the employee stated to the DOE ECP office. They fired the contractor ECP manager. What do you think they will do to me?
I think we just had a description of a textbook case of how a whistleblower should not be treated. That's essentially what we just listened to. And Ms. Black, you said you were proud of how you did your job. We are proud to be in your company today and to have you speak out.
Thank you.
Mr. Tamosaitis, I think, got a terrific introduction from my colleague, Senator Markey, and I'd just add one sentence. I think it would be fair to say we would know next to nothing about what really goes on at Hanford unless you had whistleblowers like Mr. Tamosaitis. So come on up. We welcome you.
Thank you, Senator Wyden. My name is Walter Tamosaitis. I have a doctorate in engineering. I have a professional engineering license and over 44 years of industrial service. I was the Deputy Chief Process Engineer and Research and Technology Manager in the multi-billion-dollar waste treatment plant being built by Bechtel in Richland, Washington, until Bechtel had me removed for raising nuclear safety concerns in 2010. The safety concerns that I raised had the potential for hydrogen explosions, like you saw on TV at Fukushima, fires, nuclear releases, and could render the plant impossible to run after the $30+ billion would have been spent on building it. And that's right, that's a B, not an M, over $30 billion it will cost. The safety problems that I described result from the buildup of hydrogen gas in the vessels in the very thick liquid material being processed as a result of poor mixing. I went to work the morning of July 2nd, 2010, and was called to a special meeting. I sat down. The person across the table from me told me, hand over your phone, your BlackBerry, your badge, your keys, and leave the site immediately. I asked why. I received no answer. I was escorted to the door and told never come back to the site. I was not given any reason for my treatment. It was the loneliest day of my life. After this, I was put in a basement office, essentially in solitary confinement for about 18 months with the copying machine and boxes. They hoped that I would quit and fade away just like the sunset, but I didn't. I was ostracized, not talked to by anyone, did not know whom I reported to, was not given any significant work, and not invited to any group meetings for over 4 years. One winter day during a snowstorm, I was at the office, and my wife called and said, "Where are you?" And I said, "Well, I'm sitting here as I normally do." She said, "Well, why are you there? The businesses are shutting down because of the snowstorm we were having." I said, "Geez, I didn't know that. I'll go check." So I left the basement office, went up, went into the main office area, and sure enough, it was all dark. Everybody was gone, the managers were gone, the doors were locked. At first, I thought the rapture had occurred, and then I said, wait a minute, I'm the good guy. You know, this shouldn't be this way. But it was clear nobody had thought to tell me about it and just ignored me and left me in the basement. I fought back with lawsuits with DOL, Washington State, and the federal government. My objectives were solely to see that the plant was built right and to see that no one else was treated the way I'd been treated. Having never been through this before, I didn't know where to turn. It's a first-time event in your life that you hope you'll never go through and don't really think about. I finally found one person in an organization who could help me, and that was Tom Carpenter and the Hanford Challenge organization. The 5-year legal battle was exhausting and beyond stressful. For example, I participated in 2 congressional hearings, was the cover story in Newsweek, was on TV, radio, and in basically all major newspapers around the world. With the support of my wife and family, I'm proud to say that we settled in August of 2015, over 5 years after the start, and we changed the laws. In addition, All my cultural concerns and all my technical issues were validated by outside review groups and are now being addressed. Whistleblowers are now entitled to a jury trial under the ERA where before they weren't. Most importantly, a work stoppage occurred in the waste treatment plant that was to address the technical issues that I brought up. That work stoppage is still in effect, so I'm optimistic that the plant will finally be built correctly. However, while several improvements have been made, much more is needed. Whistleblowers, as been commented, are the last line of defense against the corporations like Bechtel and AECOM who take advantage of the government to increase their profits. The contractors mislead the government and drag out projects purely for the sake of profits. I referred to a mixing problem with releasing the hydrogen gas. In 2010, Bechtel claimed the mixing problem was solved and received $55 million for that accomplishment. It is still unsolved and not resolved today and still being worked, but they got their $55 million. DOE is outmanned and outgunned by the contractors, and this has to change. Contracts have to change so they are responsible, the contractors, for their actions. For example, as been mentioned, the contractors are reimbursed by the government to fight employee concerns, while the employee, like myself and Sandra, have to foot the bill for all legal expenses. And let me tell you that over 5 years of legal expenses add up to a big chunk of change. The same contractors are used over and over and have honed their manipulation of the government to a fine, sharp edge. Laws and contract changes should be made to punish contractors who retaliate on employees, not punish the employees for bringing up concerns. Penalties should be considered that include being unable to bid on a project or disbarment for cutting corners, misrepresentation, and punitive actions. A whistleblower's trek is a long battle that no one should have to go through. In closing, I want to thank Tom Carpenter and, of course, my wife and family for the support and help I received during this long, over 5-year battle. Without it, I would not have prevailed. Most importantly, I hope that my actions have helped others. Thank you.
Thank you. Thanks, Dr. Thank you. We'll be happy to take any questions that anybody has, and I want to point out that Diane LaFaro, who is responsible for this report, is here. If anyone wants to ask questions of her, she is also available either now or as we close. Yes?
My question is for the whistleblowers specifically. The GAO report doesn't speak necessarily to the motives of the contractors. Can you tell us from your inside view, is it greed and reading headlines? What motivates them to not take seriously in terms of seeing the benefit of their
Contractors, money.
Yeah, it's deadlines, monies, and bonuses. I mean, it's deadlines, which has to do with money, performance that has to do with money. And a lot of this is, in fact, built into the contracts. I think if you read the report or visit with the Government Accountability Office, they'll tell you that this is all about everything going smoothly so they get the plus-ups that are baked into the contract. And if there's problems, they don't get those plus-ups. Yes?
Hi, Senator. Thank you for having us. I'm Dan Leone with Exchange Monitor. I hope you could tell us something about what perhaps Congress can do going forward now that we know a little bit about what has happened. What levers remain to pull here? The GAO report sort of showed the limits of using that particular lever. What else can Congress do?
Well, I think making the pilot program permanent and making sure that they're baked into all of the contracts. One of the problems was that the pilot program wasn't even added to some of the contracts at DOE. And the pilot program is basically making the 708 program more user-friendly. The 708 program is very difficult for whistleblowers. It also didn't apply didn't protect people, for example, with the Department of Justice and other places they might go with their complaints. So basically, this permanent legislation that has passed the Senate and that is being introduced in the House today will provide another layer of protection for reports going anywhere and also put some pretty stern rules of the road about reimbursing litigation costs to contractors, and also makes it much more user-friendly so that it doesn't end up being a war of who can afford a lawyer or who can get a lawyer to represent them on a contingency basis. Because the contractors have the government paying their litigation costs. So that's why this playing field has been so unlevel and so terribly unfair. Yes? I would be happy to add punitive damages as long as it doesn't keep us from getting the bill across the finish line. I'm a believer in punitive damages, but I also am a realist about the Congress right now, which is, if you take a look around, it's controlled by people who don't like punitive damages. So I'm really anxious to get this level of protection into the law, and I'm happy to look to see if that's a possibility. I would be all for it. I'm not sure if I could get 60 of my colleagues to be for it. Of course they would. Of course they would. And the business community in general, the Chamber of Commerce would lobby against it. You know, they're busy trying to put arbitration clauses in every encounter you have with a company in America so that you never have a chance to get to the courthouse. They certainly are not typically in a mood to add punitive damages anywhere. Yeah?
Thanks for holding this press conference on getting it across the finish line. Have you talked to the White House at all about this? Do you have any assurances from?
Oh, they'd be happy to. I haven't talked to them directly, but I'm confident. I've never heard a whisper of any pushback when we put the pilot program into the Defense Auth bill a few years ago. And I will talk to the White House, both this one and the next one, and make sure that they, in fact, I will say, the next Secretary of Energy is going to have some really tough questions. I would assume by not just me, but also by the senators who have worked on this subject alongside of me about how they're going to handle this eyes-on, hands-off attitude at the Department of Energy towards contractors. It has to be eyes-on, hands-on. It has to be, you've got to pay attention to these contracts and you've got to enforce these contracts. It has really just been, they have been outgunned, as the doctor said. They've been outgunned because the expertise has resided so much in the contractor community, and it's 6 to 1 in terms of the number of employees. So we've got to make sure that the next Secretary of Energy understands what a priority this has to be, and if they don't understand that, I think they'll have trouble getting confirmed. Anybody else? I want to thank the whistleblowers again for your bravery, for your tenacity, and I hope that other whistleblowers will hear of this press conference today and know that there's a whole lot of us here that have your back. Thank you.